The question is, what does it mean when it says certify? Does that mean it has to be, I understand I make the statement under penalty of oath? I don't think so. I know that as just a practicing attorney, if you put that into the substitution of attorney form, we all have that, the undersigned hereby consents to the substitution of so-and-so. Just add, we've already added just one extra sentence. I hereby certify that all discovery that I have in this matter as a withdrawing attorney has been provided to substituting counsel. So you just add that line. I believe that's sufficient because if a judge is going to get angry at you for not having done that, is he going to be angrier because you did it in a certification form where you swear that's the truth, or you represented to the court in a written document that you've done it? So I don't think that you're going to need that certification to the effect that it was done under oath. If you make that representation in writing and you sign underneath it, I think that's sufficient. Almost everything I do now, and we have Thomas here from Ridgefield Park, I do by electronic discovery. I mean, I send people emails containing a PDF of all the discovery, a PDF of the motions, whatever it is. Now, how do you document that? You just, I keep a copy of the email, in my file to show that it was sent, and I always ask people to give me a responding email acknowledging that they got my email and got the discovery. No one ever does that. I mean, it's simple courtesy, but they never do it. But nonetheless, that's how you document your file. I've never been in a case where the prosecutor didn't provide me all this material to begin with. Listen, sometimes they send me a notice and say, listen, there's an ongoing investigation, and you'll see that there's exceptions for that. And, we can't reveal this information for you yet as to what the source of our information was to get the search warrant, et cetera. Oh, that's okay. I'm put on notice that I'm not seeing something, and I can always make an application. But the real obviously change that's going on here is that in the old days, they used to say, well, listen, you come into our office, we'll let you look at it. We're not going to give you a copy. Now, you'll see in all the rules as we go through them, that whole notion that we have to go in and take a look at things, except where they're extremely bulky, has been eliminated by these revisions in the court rules. They have an affirmative obligation to provide it to you, mail it to you, email it to you, to hand deliver it to you upon your request. But I don't think under this rule, I honestly don't believe that you have to pick up the discovery. I think you only have to assert that you filed an appearance, right, that you have requested the discovery from the prosecutor's office. Mm-hmm. This is missing a word here. I believe the word is requested. Okay. And then C, that you acknowledge that I know the time, date, and place of the arraignment status conference. Gotcha. So I know where to go. So you only have to request it. You don't actually have to go and physically have possession of it. Okay. But they expect you will have read it and be ready to roll by the time the pre-arraignment, the arraignment status conference happens. They mandate it. Right. And you not only, well, we'll see, but they not only mandate that you've read it, but that you've actually had a conference with the prosecutor and talked it over. I've never had an adversarial relationship with a prosecutor, and that's the truth, not a DAG or a prosecutor. They're all old friends, and if they're not old friends, then in that conversation they become new friends. Right. Everyone is glad to speak to you. Hey, listen, what can we do here? There's some, witticisms, comments about the system or your crazy client or whatever it is, and then the two of you work together. And you build friendships and you build relationships that way. Neither one of you wants to get bogged down in stupid things like providing discovery and motions. The way, since this rule has come out, I've promulgated a form in my office in order to assist the assistant prosecutor, where we send an email to the assistant prosecutor, and I have all the topics, the motions discovery and all of that, because I don't want to, the prosecutor has 1 million files, and if you get him on the phone, get him or her on the phone, they're going to try to remember your file as opposed to someone else's file. I like to give them a heads up by email, say, listen, here's my position, here's what I need, or this is where we're going, so that they can think about it. And they say, listen, give me a call back in the next few days, or send me an email, addressing these issues, so that they have a chance to think about it, they're not caught off guard, and then you can have a much more intelligent conversation with them.